Welcome to Pinnacle Tutorials. To access our entire curriculum, join Pinnacle Tutorials and gain access to lecture videos such as this, study resources, as well as revision content to help you excel in your studies and score good grades. In today's lesson, we are going to look at Unit 1 and Unit 2 of our Introduction to Business Law course. Unit 1 covers the nature of law, morality, equity, and the organs of state here in Zambia. Unit 2 then takes us into the sources of law, in other words, where our law actually comes from. By the time we finish today, you should be able to confidently explain what law is, how it's different from morality, what equity brings to our legal system, how government is structured into three organs, and where the Zambian law is drawn from. This is a foundational unit, so if you get Unit 1 and Unit 2 well enough, everything else in this course will make a lot more sense. Let's get into it. What is law really? Let's start with a question that sounds simple but has actually kept legal scholars busy for centuries. What is law? Human beings are social creatures. We do not live alone on islands, we live in communities, in villages, in towns, in cities like Kitwe or Lusaka or Ndola. And whenever people live together, you need some kind of rules to keep things orderly. That's really where law comes from. It's a social phenomenon born out of the simple fact that we live together and need to regulate how we treat one another. Now, jurists, which is just a fancy word for legal scholars, have often for a very long time had to land on one single definition of law that everybody agrees with. And honestly, they have never fully succeeded. But the definition you most commonly come across describes law as a body of rules prescribed by human beings for other human beings to obey. From that description, we can pull out three characters that you should remember because examiners love to test on this. Firstly, law is a body of rules. Notice that it's not just one rule. It's a whole structured system of rules working together. Think of it like the human body. You don't have to just have one organ, you have many organs working as one system. Secondly, and this is the big one, enforceability. This is what actually separates a legal rule from an ordinary social rule. Think about table manners. It's rude to eat with your mouth open, but nobody is going to arrest you for it. That's a social rule. But if you drive through a red robot on the road in Lusaka traffic, a traffic officer can stop you and fine you. That's a legal rule. Because it's backed by the state, and the state can enforce it through sanctions or punishment. Thirdly, law is dynamic in nature. It isn't frozen in time, it changes as society changes, so that it continues to reflect the lives, the values, and the activities of the people it governs. The laws Zambia had at independence in 1964 are not identical to the laws we have today because our society has moved on. Now, let's talk about morality because oftentimes we confuse law and morality or assume that they are the same thing. Well, they are not. Morality actually just concerns itself with right conduct. When we talk of morality, morality just looks at what society considers to be good or moral behavior. And where does your own sense of morality come from? Usually, it's a mix of things. It may be your religion, where you were born and raised, and the general opinion of the people that surround you. Here's the key point that I want you to hold on to. Law and morality overlap a lot and they generally support each other, but morality is actually wider than law. There are things that are immoral but perfectly legal. This classic example used to illustrate this is the duty to rescue. You picture this. You are walking along the Kafue River and you see a total stranger drowning. Morality, almost everyone would agree you should try to help, or at least call for help. But when we look at it from a legal perspective, the law does not impose a general duty on a stranger to rescue another stranger. There is no crime in simply walking past. That duty only kicks in where there is already a special relationship between the two people. For example, between a parent and their own child. A parent who watches their child drown without trying to help can face legal consequences. A stranger generally cannot. So, what exactly are the custodians of morals, and who are the custodians of morals in a society? Well, custodians of morals are simply people who enforce or uphold moral standards. Three groups identify as the custodians of morality: the society itself, through social pressure and public opinion; the parliament, when it chooses to turn a moral principle into law; and the courts, when judges apply moral reasoning in their judgments. Let us now talk about equity because it's a word you hear again and again throughout this course. Equity is based on fairness, justice, and good conscience. Historically, it developed to fill the gaps left by the common law. There's a lovely phrase for this that you should remember for your exam. Equity is said to add, quote, flesh on the bare bones of the law. In other words, where the common law was too rigid, too mechanical, and produced an unfair result, equity stepped in to soften that outcome and produce something fairer. Because of this, equity gives the courts a number of discretionary remedies, meaning the court has a choice whether to grant them, that is, go beyond the usual common law remedy, which is simply an award of money damages, or to not grant them. So let's go through these one at a time because examiners love asking you to match the remedy to its definition. The first one is called a subpoena. And a subpoena is simply an order compelling a witness or litigant to appear in court. For example, if you are a key witness to a contract dispute in Kitwe and you are avoiding court, a subpoena forces you to show up. The next remedy of equity is estoppel. This is simply an element of equity which prevents a party from going back on their word in a contract. Say a landlord tells a tenant verbally that they won't enforce a late payment penalty this month. The landlord may be stopped or stopped from later going back on that promise and charging the penalty anyway. Then we have an injunction. An injunction is simply an order stopping a party from doing a specific act. For example, if your neighbor starts constructing a wall that encroaches on your plot, you could seek an injunction to stop the construction. Another element of the remedies of equity is rectification. Rectification is simply the rewriting of a contract so it reflects what the parties actually intended. Imagine a supply contract for cement mistakenly set the price as 50 kwacha per bag when both parties had actually agreed on 500 kwacha. Rectification corrects that clerical slip. Another remedy is rescission. Rescission just allows a party to unilaterally withdraw from a contract, and it does this by effectively unwinding the deal as if it never happened. In short, it reverses a contract by providing withdrawal. Lastly, we have appointment of a receiver. So, this is where the court appoints a person to manage the income of a business, often used where a business is in a financial distress or under dispute. So, these form the remedies that are provided for by equity. Let us now go on to look at the legal systems of the world. Zooming out a bit, a legal system is simply the application of rules and regulations to maintain order and fairness within a community. Around the world, there are three major types you need to know. Firstly, the civil law system. Secondly, the common law system. And thirdly, religious law. Let us now briefly look at each one of these. The civil law system, which is based on codifying statutes into a written constitution, is part of the systems of law, and this traces its roots all the way back to the Roman Empire. The common law system, which is characterized by a general lack of codification, and in most common law countries, there isn't a single written constitution covering everything, although Zambia, as you see, does have one. The third is religious law. The religious law system is based on religious texts. Think of things like the Sharia law, which is the Islamic law, or the canon law, which is the church law. Now, one might wonder, where does Zambia fit? Zambia is a common law country. Our legal system is based on the English common law system brought over during the colonial period, but it has since been adapted over the years to reflect our own local sense of justice and our own ethos as Zambians. Now, what makes a good legal system? There are several characteristics that make a good legal system, and we will go through them one by one. For a legal system to actually work, it has to be respected and followed by the people it governs. It needs certain qualities. One of those qualities is certainty. Certainty in law just simply means that the law must be predictable. If you're signing a lease agreement in Indola, you need to know in advance what the rules are so you can comply with them confidently. Another attribute of a good legal system is comprehensiveness. The law should be wide enough to cover all disputes and social issues that might realistically come up. Another good attribute of a good legal system is simplicity. The law should be written in plain language that an ordinary person can understand, not just lawyers hiding behind Latin phrases. A good legal system is also accessible. By accessibility, we mean that services such as going to court, hiring a lawyer, or filing a case should not be so expensive that it locks out the average citizens. Good legal systems are also flexible. That is, the law must be able to adapt as society changes and as new kinds of problems emerge. Think about how the law has had to adapt to mobile money and online business in recent years. And finally, the law that is good has moral values. The law should try to reflect the moral values of the society it serves, because a law that's seen as immoral is likely to be is unlikely to be respected or obeyed in the first place. Therefore, a good legal system should reflect the moral values of the society it has been made for. I would like to urge you to take note of this because this is actually a favorite topic in exams and you would like to score yourself a few marks in case it pops out. Now let's look about how the government is actually structured. Okay? The Zambian constitution establishes three main organs of state and each one has a distinct job. This is what we call the separation of powers. And it exists precisely so that no single arm of government becomes too powerful. The three organs of state in Zambia include the executive, the legislature, and the judiciary. Let us now look at each one of them briefly. The executive is headed by the president, and it also includes the vice president and the cabinet. It's made up of government ministers. Their job is policy formulation and the general day to day administration of government. The second one is the legislature. The legislature or parliament is actually just what consists of the president together with the National Assembly, which is headed by the speaker. The National Assembly is made up of 150 elected members plus up to 8 members who may be nominated by the president. Parliament's primary role is to enact laws and scrutinize, meaning it should check and question the work of the executive. The third organ of government is the judiciary. The judiciary is headed by the Chief Justice. Its job is to adjudicate, that is, to decide on criminal and civil matters. It's made up of the Supreme Court, which is the highest court of the land, and then the High Court, the Industrial Relations Court, the magistrates, and the local courts. If a party is unhappy with a decision of the lower court, they can challenge it through an appeal to a higher court. So there you have it. Executive makes and runs policy. Legislature sees to it that the policies that are made and run by the executive fall within the bounds of the law. And aside that, the legislature also makes the laws, and the judiciary interprets and applies those laws. That wraps up Unit 1. Now let's move into Unit 2, where we will look at where Zambian law comes from actually. Having looked at what law actually is, it's now worth asking, where does it come from? In Zambia, law is drawn from a number of sources: the constitution, statute law, delegated legislation, case law, custom, and equity. There are also less prominent sources of law such as statutory interpretations, treaties, and the books of authority. Let's take these one at a time. The Constitution. Firstly, the Constitution is the supreme law of the land. Everyone, every citizen, and every organ of state is bound by it, and it is regarded as coming directly from the people themselves, and its purpose is to promote orderly governance. Among its key features, the Constitution deals with citizenship, which can be acquired by birth, by descent, or through naturalization. It also contains the Bill of Rights, which protects the fundamental rights like the right to life, liberty, security of the person, and freedom of expression. Here's a point worth remembering. Every right protected under the Constitutions comes with a corresponding obligation. Rights and responsibilities go hand in hand. Then we have legislation, which is also statute law. Legislation refers to acts of parliament, which are laws that have been formally passed by our legislature. Under our constitutional theory, parliament is sovereign. What does that mean in practice? It means that as long as the proper procedures were followed, the statutes parliament passes must be obeyed by the courts. As a general rule, courts in Zambia cannot simply strike down or invalidate an act of parliament. Now, how does a bill actually become law? It's a journey through several stages, and I want you to picture it almost like a product moving through a factory line, getting refined at each stage. It starts with a green paper, a consultative document that puts proposals out for public discussion. Then it comes as a white paper where government firms and forms up a proposal. From there, the bill goes through a first reading where it's formally presented to the National Assembly, which is then followed by a second reading where its general purpose is debated. Then comes the committee stage, where the bill is scrutinized in detail and amended. After that, the reporting stage, where the amended bill is debated again. Then a third reading, which is a final review, and finally, presidential assent, where the president signs the bill into law. Once a bill lands on the president's desk, he has two options. He can sign it into law or he can withhold his assent and send it back to the National Assembly with proposed amendments. When a bill is signed into law, it's said to be accepted, and when it is rejected, it's said to be vetoed. One more specific point that is worth remembering, especially for us in Zambia, is that our law also incorporates certain English statutes that were in force as of the 17th of August 1911, along with certain British acts that had been specifically extended to Zambia. That date, 1911, tends to come up in exams, so make it a mental note for you to remember. It is also only fair for us to look at delegated legislation, which is also called secondary legislation. Delegated legislation is where the parliament hands some of its lawmaking power down to a subordinate body. This can take the form of statutory instruments made by government ministers or bylaws made by local authorities like your local city council. Why does Parliament do this? There are real advantages. It saves parliamentary time because Parliament simply cannot sit and debate every tiny technical detail of every regulation. It also allows for quicker, more detailed regulation that can also be tailored to local conditions. For example, A council bylaw regulating market vendor stores in a specific township can pass quickly, unlike letting it to go through the entire parliamentary process. But there are also disadvantages to delegated legislation. Delegated legislation has been criticized as the new despotism, meaning it allows unelected civil servants to effectively make laws. And because there is so much of it, ordinary citizens genuinely struggle to keep up with the regulations that apply to them. So, how is it controlled? In two ways. Parliament controls it through its committee, and the courts control it through the judicial review by checking whether a parliament regulation is ultra vires, meaning it went beyond the powers that were actually delegated to the body in the first place. Let us move on. Another source of law is custom. Custom is considered to be the most primitive source of law, the oldest one, really. It's far less prominent today than it was, but it still plays a role. It fills gaps where statutes are silent, and courts often rely on custom to define specialized terms or to imply terms it cannot contract that the parties themselves didn't expressly state. From custom, we also have judicial precedent, which is case law. This source of law, also called common law, is built from the accumulation of legal principles that judges have laid down in past cases. At the heart of this is a doctrine called stare decisis, a Latin phrase that literally means to stand by decisions. Think of it this way: if two people commit the exact same offense under the exact same circumstances, fairness demands that they should be treated the same way by the courts. That's what stare decisis promotes: equality, predictability, and efficiency in our legal system. Now, within a single judgment, there are two components you must be able to tell apart because this is heavily examined. The ratio decidendi, which is the actual binding legal reasoning, the core principle the judge relied on to reach their conclusion. That part is the binding on future courts' decisions for matters that are of similar nature. Then there is also what is called the obiter dicta. On the other hand, these are side remarks that the judge makes along the way, comments that don't form part of the actual judgments. They are usually persuasive but not binding, meaning the future court can consider them but doesn't have to follow them. Now, can a judge ever avoid being bound by an earlier precedent? Yes, they can, in three ways. The first being distinguishing, where the judge shows that the facts of the present case are materially different from the earlier one, so the old precedent simply does not apply. They can also apply overruling, where a higher court overturns the legal principle set out in an earlier case, usually a different case entirely. And they can also apply reversing, where a higher court on appeal overturns the actual decision in the very same case that's now before it. Let us finish Unit 2 by looking at the hierarchy of courts in Zambia because this tells us exactly who is bound by whom. The Supreme Court sits at the very top. It binds all other courts in Zambia. Interestingly, it's generally bound by its own past decisions too, unless there are compelling reasons to depart from them or unless the earlier decision was made per incuriam, meaning it was decided in ignorance of a relevant law. Below that, the High Court binds the subordinate courts and the local courts. And finally, the subordinate and local courts are themselves bound by decisions from the higher courts, but they don't create binding procedures of their own for other courts to follow. And that brings us to the end of today's lesson. Let's do a quick recap. In Unit 1, we learned that law is a body of enforceable dynamic rules, and morality is broader than law, that equity exists to soften the harshness of common law, and that Zambia runs a common law legal system, and that our government is split into the executive, legislature, and judiciary. In Unit 2, we saw that Zambian law flows from the constitution, legislation, delegated legislation, custom, and judicial precedent, and we looked at how the courts are structured from Supreme Court all the way down to the local courts. In our next session, we'll move on to Unit 3 and 4, which looks at statutory interpretation, common law, and equity, while we'll dig into some really interesting cases. Until then, keep revising and remember, join Pinnacle Tutorials for the full curriculum, lecture videos, study resources, and revision content to help you excel and score good grades. See you in the next lesson.